minister and who should attend to sessions. You recall?
Yes, I can recall.
And I put it to you that the determination of the delegation is normally made by the permanent secretary. Do you dispute that?
I'm still disputing that.
Did you investigate who makes these determinations?
This determination as to who should accompany the minister. If I just refer to the last letter that we dealt with, the letter of the 19th of July 2013, with its attachments. This letter was among the letters, as I just have testified before, that it was among documentations that were seized from the office of the minister. By that time, the applicant was a Minister of Fisheries and Marine Resources. And the document was found with the attachment as it is. Hence, I refer it that it is a one document. If you are reading this document, just in the first paragraph, it is saying, I am writing to His Excellency. And the person who signed this letter is the applicant. If it could be the Prime Minister or the Permanent Secretary who could draft this letter, he can refer to the Minister, who said the Minister is requesting. And if you also look to the attachment is saying, attach find the list of the delegates who will form part of my visit. The minister, the prime minister, the permanent secretary was not the one who was going to visit Angola. It was the applicant himself. Which means he was the one who determined who should accompany him.
So you investigated who determines the delegation?
Yes,
you're just drawing conclusions from this letter?
Yes, he's the one who determined who should accompany him.
Let's go to bundle 3, divided 12, exhibit WW13.
Bundle 3 is which one?
It's a letter dated 18 July 2013.
And which bundle is it?
Oh, perhaps you maybe don't have that bundle, but I can provide you with a copy of the letter. Sorry? Divided 12, bundle 3.
Mr. Biokas, are you done with bundle 1? I want to request back my bundle, but if you are still going to
I will refer to bundle 1 again.
That's fine.
Your Lordship, maybe I can request, I did prepare one for the witness. I believe that Mr. Esau has a copy of bundle 1 that I prepared for the witnesses.
Okay.
Or maybe you can perhaps borrow his. Your Lordship, while Mr. Esau is preparing that bundle, I can proceed.
Yes, sir.
Yes, as it pleases. Now, Mr. Kayangela, in respect of before we turn to that letter, I did put it to you that my instructions are that the letter of 19 July 2013 was prepared on behalf of the former minister, Mr. Esau, by the permanent secretary.
I disagree to that.
And if we go to the letter of the 18th of July 2013, are you there?
I'm there.
This is a letter dated 18 July 2013, whereby it is under the letterhead of the Ministry of Fisheries and Marine Resources, and it was signed by the permanent secretary.
That's correct.
Yes. And it indicates, and it reads as follows, sorry. I am pleased to confirm that the Minister of Fisheries and Marine Resources, Honorable Bernhardt Esau, will undertake an official mission to the Republic of Angola from 24 to 28 July 2013. He will be accompanied by Mr. Shaki Shangala, Chairperson of the Law Reform Commission, Ms. Aina Ipinge, Deputy Director of Policy, Planning and Economics, and Ms. Indion Weno Shea, Personal Assistant to the Minister. The purpose of this letter is to kindly request your office to communicate this confirmation to the Angolan Minister of Fisheries, Honorable Victoria Neto, through the diplomatic channels. Furthermore, it will be highly appreciated if you could inform your embassy in Luanda of this visit. Attached, kindly find the proposed agenda as well as the flight details for the delegation. Your assistance in this matter is highly appreciated. Now, my instructions are that it was the permanent secretary who determined who the delegates will be.
This is not what this letter is saying. This letter is confirming, which means if you are confirming, there might be something that has been brought to your attention, and you confirm. She never said that she's appointing the delegation. She was confirming.
And this letter is dated before the letter of the 19th of July.
That's correct.
Now, you have not investigated, besides looking at the correspondence, who determines the delegation. Just listen to the question. You have not investigated at the ministry who determines the delegation, correct?
That one I did not investigate as to who determined the delegation.
So you will then not be able to say whether or not the permanent secretary determined the delegation for this fact-finding mission in July 2013.
If we can determine, it should be with the consent of the applicant, who is the head of the ministry.
Yes, she would inform him and then he would sign off the letters prepared by her.
With his consent.
Yes, with his consent.
Yes.
But the determination is in essence made by her.
That one I cannot say.
Now, what you would also notice from this particular letter, there it indicates in the content of this letter who the delegates will be. You see that?
I see.
The names are there explicitly outlined.
Yes.
And that also goes for the delegation that went to the signing of the bilateral agreement, the MOU.
This letter.
Not this letter, there's a further letter.
I'll comment if we come to that one.
Okay, let's quickly go there. It's under divider 9. Divider 11, bundle 1. Are you there?
Should be the other bundle.
Bundle 1.
Okay,
This one. Divider 11.
Yes, I'm on that device.
Yes. That is the 9th of June 2014.
That's correct.
And that is in respect, it's a letter prepared by the acting PS, Bonifacius Amutse. You see that?
Yes.
Inquiries on top is Evalua, the former PS, correct?
That's correct.
And it's addressed to the ambassador in the office of the Ministry of Foreign Affairs.
That's correct.
Yes. And in that particular letter, it indicates that I would like to submit the names of the officials that are to accompany our Honorable Minister of Fisheries and Marine Resources to the Republic of Angola from 17 to 18 June 2014.
That's correct.
And in this particular letter, it then lists the officials.
That's correct.
So both letters were prepared by the permanent secretary and signed up by the permanent secretary.
The person was submitting
The names,
the names,
yes.
and he did not indicate that he was the one who have appointed those people. He was submitting the names.
And in your investigation, could you conclude who determined that delegation? You cannot.
I cannot conclude, but the applicant should be involved.
And the applicant is saying that those names were provided, except for NBC officials, those names were provided by and were delegated by the permanent secretary. That you can't dispute.
If he was delegated, if the PS was delegated, then he should be delegated by him.
The PS determined the names and then informed him. Because that is part of administration.
I'm not in agreement with the statement of him.
But you don't have evidence to the contrary.
Yes, but I will not agree to what he said.
Now, it would appear that you would not agree to anything despite there being no evidence.
I will not be forced to agree. If I disagree, I disagree.
So now, after these delegations was then determined by the permanent secretary, the parties then traveled, correct? Let's go back to the first meeting in July.
They have traveled, but I will not say it was the determination of the permanent secretary. But yes, they traveled.
But you can also not dispute.
Yes, based on that letter that I was just referring to, one of the 13, I dispute that it was not the PS who appointed delegation.
Now you see, Mr.
The
Kayangela,
request was made by the applicant himself.
and the applicant is saying that there was never any attachment to that letter prepared by the PS of 19 July 2013.
The attachment was found in his office, so it was there.
That attachment, he's saying that that attachment was added there.
Unless you have to prove who have added it, but it was there. It was found among the documents in his office.
But it's
And
also,
he was the one who signed the letter.
but we have confirmed that that letter does not refer to any attachment. An attachment of a list,
Which letter?
the one of 19 July.
It's not referring.
It's not referring to any attachment about delegates.
I said the letter is one. In the last page, it says attached. What was attached is a list, and that is the attachment.
You see, Mr. Kayangela, that is the problem that we're having. That letter is saying attach list. And we've established, or at least it was put to you, that once a letter or document is attached to a letter, they will refer to that attachment.
This is an attachment. The last page is an attachment.
And it's not
Although it
referred.
was not reflected in the letter itself.
And if you go to Exhibit WW13, that one also refers to attachments.
Which one is it?
The one of 18 July 2013. The last sentence, attach kindly receive the proposed agenda as well as the flight details for the delegation.
Yes, it refers.
Both letters, the one of 18 July and the other one that we went through now at Divider 11 of 9 June 2014, they explicitly outline who the parties are, the delegates are, in the content of the letter.
Yes.
In the letter of the 19th of June, they do not refer to the content,
But
who the
it's
delegates.
it's the
Let me just
same-
finish, Mr. Kayangela.
Yes.
It does not refer to the delegates in the content of the letter.
Yeah, it doesn't refer, but it's the same people who were mentioning in this letter that which is having listed people.
It's exactly the same,
It's the same people.
yes,
Yes.
but it was not attached.
I still say it was attached.
We can move on.
We can move on.
Now, after that meeting, or after that letter of 18 July 2013, Mr. Esau then traveled with the delegates, as determined by the peers. And according to his testimony, it was more of a fact-finding mission that they conducted. And minutes was prepared in respect of that particular meeting.
Which which meeting are you referring to now? Is it now the one of the
Exhibit G.
July, or is it the one of the 2014?
The one of 2013.
Yes, there were minutes. I have testified about the minutes.
Do you have those minutes? It is marked Exhibit G. It is also under Bundle 1, Divider 7. Your Lordship, I believe that this exhibit was marked twice. It is Exhibit G as well as Exhibit XX. XX4. XX5 Roman 4. I mean, get it to my learned friend. Actually,
I did not say Roman. Roman 4. Is it not only up to Roman 3?
Roman 3.
Your Lordship is Roman 3.
Yeah.
XX.
5 Roman 3.
Sorry, Your Lordship, what is it's XX5.
Roman 3. Is
Roman
the
3.
minutes of what is the meeting between the ministerial delegations
Yeah.
of fisheries of the Republic of Angola and fisheries and marine resources of the Republic of Namibia. Is it that one?
Yes, Your Lordship.
XX5 Roman 3.
And as well as Exhibit G.
As
It's
well
part of
as-
Bundle 1.
Okay, my bundle 1 is that one. I will not be able to. That's fine.
Now, according to Mr. Esau, he signed off these minutes.
Yes, he signed.
And what these minutes provide for is, in essence, that if you go to the second page,
I'm on that page.
Mr. Esau testified that what is indicated there on top during the working meeting of the technical teams, both parties, after addressing the said items, conclude as follows. So what he's saying, after the discussions with the minister, or after the discussions by the technical teams, this is what they proposed and concluded, is that there should be a review of the protocol on fisheries and aquaculture signed in Windhoek in October 2007.
Can you repeat again?
After the technical teams have met, during the purpose of the week that there was the 2-3 days that they were there. There was a working meeting of the technical teams where they then concluded as follows, the technical teams.
Are you referring to the meeting of Angola? You are referring to the meeting in Namibia?
The meeting in Angola, because they were also the technocrats also went with the deputy director.
My lord, I have an objection. Where is he getting that there was anyone else other than the people who are mentioned in the letters? He has referred us to 2 sets of letters. Now he's talking of other technical teams. Where is he getting that from?
My instructions, Your Lordship, is that it was the technical teams that concluded as follows. And part of the technical team that was spearheading the technical team there was the deputy director, was Aina.
Are you saying that in addition to the delegates mentioned in the letters that you referred to, there were other staff from the Minister of Fisheries who accompanied the minister? Or are
No,
those
Your Lordship.
letters different from what you are asking now? Because in the letters that you just pointed out to him, the delegates' names are appearing.
Yes.
And your colleague is saying that that constituted the team.
Yes, the team.
Where are you getting
But
the
the
other names?
No, you see, my instructions are, Your Lordship, that
Yes.
the technocrats were then represented by Ms. Aina Ipinge, the Deputy Director for Policy Planning and Economics.
At the same meeting?
Yes, at the same meeting.
Okay. Maybe just rephrase the question
Yes.
for him so that he can follow.
So part of the technical team that was assisting Mr. Esau was the Deputy Director, Ms. Aina Ipinge. She was part of that meeting, correct?
I'm not privy to such information.
Okay. I'm putting it to you that those are my instructions. Any comment?
My comment on this, I will say that there was no any technical committee meeting held for this visiting. If there was one, then Mr. Shanghala could not wrote a report on this issue, who could also not participate. He's not part of that committee. Unless you can provide me any minutes for that technical meeting that was held in Angola. There was no such.
Mr. Kaingela, you were not there.
I was not there, but there's no such.
So you will not know.
Proof. Unless you can prove me wrong with something tangible that it can say there was such a meeting. This meeting was held by the applicant and his co-accused, Mr. Shanghala. The PA, she was there. Why was she not taking minutes or taking the one who have to write a report?
Mr. Kaingela, you're not here to ask me questions. You're here to answer questions.
I will answer your questions.
And my question was, you were not there, correct?
I was not there.
Yes.
Yes.
And these minutes refers to during the working meeting of the technical teams. Does it not?
That's what I say. I'm not aware of any technical meeting that was in Angola.
Because you did not investigate these minutes, did you? The contents you didn't investigate. Is it not so?
I don't know which content you are referring to.
During the working meeting of the technical teams.
But you never referred that it was a meeting that this one in Angola.
Yes. But you would not know, Mr. Kayangela.
The only technical meeting that was there, it was the one that was held at Safari Hotel. And those are, that is having the minutes. That is having proof.
We will get to, there were various other meetings that were composed and engagements between the two parties, the technocrats.
I understand. But in this one, this is not specific that saying that this meeting that you are referring to was done in Angola.
Now, what do you understand from the minutes?
It said during the working meeting, they did not refer to which one.
So you don't know.
And the one that I know is the one that was held in Windhoek.
But you don't know of all of them, Mr. Kayangela.
Same as you, yes.
You don't know. I'm just acting on instructions. I don't know what
Yes.
happened.
Yes. I don't know.
So if you don't know, say you
But
don't
there's
know.
no any proof that there was one held in Angola.
Now, what was then discussed and what was then reported and concluded was that considering that the protocol on fisheries and aquaculture signed between the two governments in Bandung has lapsed, the parties agreed to update the protocol and fisheries and aquaculture based on the current realities of the fishery sector of both countries. In this regard, the amendments deemed important were introduced for the preparation of a new draft cooperation framework whose copy is attached to these minutes. With due regard to the requisite procedures governing the approval and the signing of the international agreements in both countries, the ministers will be required to conduct further consultations and in due course will exchange drafts for consideration. Now, Mr. Kayengela, from the reading of these minutes, there was no discussion of any scheme or anything untoward between the two ministers.
Yeah, on these minutes, yes. But this is the protocol that they have intercepted.
So from the minutes that depicts what actually happened during these meetings, there's nothing untoward.
Come again?
From the minutes that depicts what actually happened during this visit that is signed by both parties,
Yes.
there is nothing untoward.
Yeah, there is nothing. Yes, you're saying.
What you, however, rely upon is a report that you indicated that was prepared by Mr. Shangala.
Yes.
And was this particular report signed by Mr. Shangala?
It was not sent.
And
And
the-
you can recall
And the
in
report,
my testimony.
okay.
There
So
was
let
an
me
email that Mr. Shangala shared with me, Mr. Johannes Stephenson, on the 28th of July. It was the time when this meeting was going on, or it was held. And he was explaining, he was talking as to what the two ministers have discussed.
So what he's explaining what the two ministers discussed is not reflected in the minutes what the two ministers actually discussed, correct?
It was not reflected in the minutes.
Now let's go and deal with that email then. Do you recall where that email was? It is exhibit R1, and it is also under bundle 1. You have bundle 1 there with you? Under divider number 15. Are you there? It is also part of exhibit XX5, the smaller bundle. XX6. My apologies. So, Your Lordship, just for completeness sake, is it exhibit XX5, Roman 6? XX6. Okay. I then have it marked wrongly, Your Lordship. XX6.
Which one is it, Mr. Marantesi?
Volume 7.
X6, my lord.
XX6.
Yes.
Yes, volume 7. Yes, I have.
Now, Mr. Kayengela, your testimony during examination in chief was, in essence, and you can correct me where I'm wrong, was that after this meeting took place, or during this meetings took place, Mr. Shangala, who was part of the delegates in Angola, he then reported to Joanna Stephenson by way of email.
That's correct.
And during that report, he referred to what the ministers discussed and what he will do.
That's correct.
Now let us go to that particular email. Are you there?
Page number.
No, it should be this is page 2, 787 on top.
Yes, I'm there.
Now, I must point it out to you for, obviously, for the record to be clear. In essence, I believe that these documents were also disputed on the basis of authenticity, but since they are deemed relevant, we will deal with them. So, Mr. Shangala, according to this document, wrote an email to Joanna Stephenson on the 28th of July 2013, and the time there is 1:28 a.m. One 28 a.m. You see that?
I see.
And obviously we can't speculate, but it would appear that it didn't go through. That's why he forwarded it again on top to Joanna Stephenson on the same day, July 28, 2013, at 12:30.
I don't know what had happened there.
But you testified that it seems to be forwarded. You recall?
Yes, it's saying forwarded message.
Okay. And what he's saying is, dear Joannes, you may notice that I am corresponding to you directly without consulting James and Fitty as yet. Until further notice, that is, until I inform you, please do not share this document. I am only sharing it with the minister as he still needs to discuss with his counterpart. Please make input into it so that he can understand the deal, and I will extract from it something I need to send my counterpart by Monday. Tentative meeting to Saturday next. Therefore, please look into it and we can converse, or you can simply adjust it so I can print and give the minister tomorrow at breakfast. And by the time that I get into the aircraft, we know how to go and you can inform. I will copy them, James and Fitty, on way forward. I trust you understand. You there?
Yes.
Yeah. Let's just quickly dissect it firstly. So, number one, this email was addressed on the 28th of July 2013. It then refers to, I am only sharing it with the minister as he still needs to discuss it with his counterpart. From your investigation, who could you establish was the counterpart?
The counterpart could only be the Minister of Fisheries in Angola.
Did you investigate that, or are you just drawing conclusions?
These are the two ministers that were involved in this protocol, in the discussion of these protocols. And these were also two ministers that were involved with regarding to the issue of the quotas, or the memorandum of understanding that they have signed.
And the document attached was the Opportunity Angola.
That's correct.
From your investigation, could you establish whether this document was shared with Mr. Esau?
I never found that it was shared with him.
They must suck his emails, or let me say they had access to his email.
I'm not a hacker.
Deloitte, they accessed his emails.
Yes.
Could they find any proof that he shared this opportunity Angola
There's
with the
no
minister?
any proof, and there was no need
There's none.
for Saki to send it to Esau because they were together. He can simply hand it over to him.
On the 28th. Oh, he said he would give it to him the next day.
They were together. Where should the email?
So you couldn't find it at his house. You don't know whether he received it.
I did not find it at his house.
So you will not be able to confirm whether Mr. Esau received that document. Isn't it so, Mr. Kayangela?
It was not sent to him, as I said.
Yes. Now what it's also saying is I need to send to my counterpart by Monday.
Yes.
Did you investigate who his counterpart is? Without just drawing conclusions, did you actually investigate?
The counterpart, it was the son of the minister of fisheries in Angola. He gave a statement to that regard.
And he received this document.
I don't have proof that he received it.
You said he gave a statement. He's the counterpart because he's referring to I will give it to
But
my
I never said
counterpart.
that he attached this document to his statement.
But does he refer to the document in his statement?
He never referred to the document. He referred to the discussions.
Okay. He then also goes on to state that, please look into it and we can converse, or you can simply adjust it and print it and give it to the minister tomorrow at breakfast.
Yes?
And the day after if he's saying tomorrow, he's referring to the day after the 28th, correct?
That's correct.
So then the tomorrow would have been the 29th of July that he would have given it before he steps into the aircraft.
That's correct.
So, according to this email, which authenticity we dispute, it indicates that on the 29th, as we have now dissected this email, he would have given it to Mr. Esau or discussed it with him.
Is it a question? Can you rephrase your question again? I'm not catching you.
He said we can adjust, so print and give the minister tomorrow at breakfast. And by that time, when we get into the aircraft, we know how to go and you can inform James and Fiti on the way forward.
Yes, so that is what he's saying.
Come the 29th. Tomorrow.
AM. AM is early morning, 28th early morning.
And but he's referring to tomorrow. It's still the 28th.
Yes, he referred to tomorrow.
And what is tomorrow after the 28th?
It's 29.
29th.
Yes.
Now, according to my instructions, are that Mr. Esau did not have breakfast with Mr. Shangala. And you can't dispute that.
I'm not disputing that I was
Yes.
not there.
He was also not provided this document with Opportunity Angola on the 28th or the 29th, or by email. You can't dispute that.
I cannot dispute.
I'm not, it's not an objection as such, but if you look at it, my lord, this email, the times which are there are midnight, and the breakfast can only be had some few hours after midnight at 7, 8 a.m. So I don't know where my friend is bringing in the 29th, because the next breakfast will be had on the same day, on the 28th. And also this email He's not saying that I'm going to have breakfast with the minister. He's simply saying at breakfast, I'll give him at breakfast.
Yes,
Yes, my lord. That's,
I understand.
Your Lordship, it's really getting to me a bit. My learned friend stands up and every time he gives his interpretation on a particular document, what is the purpose then of re-examination? Isn't it for him to clarify issues that he thinks that I didn't, that created doubt or anything?
Okay.
There's not even a proper objection. He's coming and he's testifying how he interprets the document. And then that allows the witness then to run with that interpretation
So you are saying it will be best dealt in re-examination?
in re-examination, as it pleases the court.
Correct. You may proceed.
So, Mr. Kayangela, what I'm putting to you is my instructions is that Mr. Esau did not receive this opportunity, this document, opportunity, Angola, either on the 28th per email or the 29th or any day thereafter. He was not even aware of that document.
Just like I said, I did not find that this document reached him, and I'm not disputing what he's saying now.
What he's also saying is that he left early on the 28th of July. He traveled out of Luanda and he did not have breakfast with Mr. Esau. With Mr. Shangala. My apologies.
The email did not say that he was having a breakfast with him.
Either on the 28th or the 29th.
Doesn't say so.
Now you took us through that opportunity Angola, that document. You recall?
I recall.
And it indicates then how they will exploit the resources of a joint venture. Are you there? Opportunity Angola.
Yes, I'm there.
Yes. Now, from what Mr. Shangala, at least according to the documentation here, that differs from what was actually discussed and incorporated in the minutes signed between the two ministers, isn't it so? You can compare the two, Mr. Kayangela, the minutes and the document that he's referring to.
Yeah, the minutes was based on the review of the protocol that was in existence.
And what Mr. Esau came to testify, and he provided the court with this email, is to say that this is yet again another example as to how his name was used, and that his name was being floated around.
If it was used by a person whom he take along.
And a person who he testified that was initially brought in by the permanent secretary as of from 2012 to review, and then that was put on the delegation list by the permanent secretary, which you can't dispute.
There's no such evidence.
There's also no such contrary evidence, isn't it so?
That's correct.
What Mr. Esau further testified, and I want to put this to you, is that there were actual technical teams that were involved. Did you find out who these technical teams were in your investigation?
If I'm not mistaken, I could come across such documents among the documents that were seized from his office by the time he was a minister. I can confirm they were technical teams.
So there were technical teams.
Yes.
And these technical teams were working on the protocol as well as the bilateral agreement.
There was no an issue of the bilateral agreement in this matter. What was there? It was a review on the protocol.
On the
that was-
protocol.
Yes.
Okay. But I'm putting it to you that there was also a technical team that was working on the bilateral agreement.
Which bilateral agreement?
The MOU between Namibia and Angola from the Ministry of Fisheries side. And then there was one on the side of Angola.
I cannot say that there was another technical team, apart from the one that they have just indicated that they were reviewing the protocol.
Yes, it was the same technical team. For the review of the protocol, it happened more or less the same time, together with the bilateral agreement. Did you investigate that technical team?
I did not investigate the technical team.
So then you can't dispute that there was a technical team working on the bilateral agreement.
On the protocol, I can confirm there was a technical team. The bilateral agreement you are referring to, I don't know which one.
The MOU between Namibia and Angola.
They were working on that protocol. They were reviewing that. They were tasked to review the protocol. Then, when this memorandum of understanding was signed, that's why I said the accused persons, they intercepted this process and used that memorandum of understanding for their own benefit. And that's why the reason that the quotas that were issued under this bilateral memorandum of understanding, they benefited the accused persons. They have intercepted that project, that process.
We will get there. We will get there with the benefits. My question to you was simple. Did you investigate whether there was a technical team that was working on this agreement?
Not on the bilateral agreement, as I said.
Now my instructions are that there was a technical team.
I don't have such evidence.
Nor do you have evidence to the contrary since you didn't investigate it.
I have, for those who attend there, who were reviewing the protocol, as I said.
Mr. Kayangela, after that, and after the technical teams were working on this bilateral agreement, there was a first draft that was prepared.
I don't know why you are referring to a bilateral agreement.
In your testimony, you referred to a bilateral agreement, Mr. Kayangela. Is it not so? Your examination in chief.
I talk of the protocol that was signed.
Now I'm talking about the
2007.
agreement now, the MOU.
The MOU, yes.
Yes.
It is written memorandum of understanding, not a bilateral agreement.
Then there was advice sought from the Attorney General. You recall that?
That's correct.
I want you to go to, do you have bundle 1 there with you?
Yes.
Divider 22. No?
Yes, I'm on that divider.
Not divider 22, my apologies. Should be that letter. That's the letter of 20 October 2014. There was a letter dated 25 October 2013. Are you aware of that letter?
25 October.
Yes.
You can just refer me to that letter.
Lordship, I'm just quickly looking
Yes.
for the letter.
Yeah.
Lordship, I believe that that was one of the letters that was referred to during cross-examination by Mr. Lutobesi. But for the purposes of progress and not to waste any further time, I can proceed, Your Lordship. I will get back to that letter.
Okay.
Just to indicate to you, Mr. Kayangela, that the permanent secretary then prepared a letter on behalf of Mr. Esau, in which they provided the Attorney General with a draft copy of the MOU. Are you aware there?
I will comment on it if I saw the letter.
Can't you see it? Okay. And that was after they then received the draft agreement from Angola. And the draft agreement was sent through the office of the permanent secretary.
That's correct. That one I can confirm.
Okay. And the Attorney General then replied to the Honorable Minister, then Minister, Mr. Esau, on the 11th of December 2013. You can go to divider 8, 9, bundle 1.
Nine.
Yes, 9.
Yes, I'm on that letter.
Now, you've already testified to this letter at length, and you testified, in essence, that the Attorney General was of the view that Angola wants a non-binding agreement.
That's correct.
And what Mr. Esau then came to testify is that after receipt of this particular letter of 11 December 2013, he then forwarded it to the office. In fact, the letter was for the attention of the permanent secretary.
That's correct.
See that?
Yes.
And whilst with the permanent secretary, there were then further engagement between the office of the permanent secretary and the technical team with that of Angola in terms to consider obviously the advice of the Attorney General and to workshop the agreement further.
That one I cannot confirm. Whether there was any further engagement.
Further engagement. His testimony is actually that there were further amendments made after the scrutinized copy was provided by the Attorney General. Are you aware thereof?
I'm not aware of any further amendments, apart from what was provided by the Attorney General's office.
Because they said that according to Mr. Esau, it was for the agreement not to be just an MOU or just an understanding. They wanted it to be an agreement. A binding agreement.
As I said, if there was further engagement, I'm not aware of the further engagement. What I know is that yes, the draft was submitted to his office by the PS.
And if you go to page 2 of that agreement, on top it will be 122, just after that letter. This is now the scrutinized copy from the Attorney General.
Yes,
Are you there?
yes, I'm there.
Yes. You see here, have reached the following understanding, just above Article 1.
Yes,
And here this particular document is referring to the parties having an understanding. You confirm that?
maybe you can ask
And-
again.
An understanding, not an
You said
agreement.
they've reached the following understanding.
Understanding, yes.
Yes,
And this is the copy that they received from the AG, the scrutinized copy.
you are correct.
And then subsequently, the agreement was then signed in 2014,
I will still refer to it as a memorandum of understanding.
Memorandum of Understanding.
That is how I will refer to it.
Can we please go to the one that was then signed later? We can go to bundle divider 13.
Yes, I'm on that one.
So according to Mr. Esau, after they received the scrutinized copy from the Attorney General, the agreement was further workshopped. You don't know anything there.
I'm not aware of
Okay.
workshops.
And what you also highlight to the court that as he was advised by the permanent secretary that instead of it now being an understanding, it was then an agreement. And if you go to page 3 of that agreement,
I'm on that page.
yes, above Article 1,
Yes,
it now reads that the parties have agreed as follows.
that's correct.
You see that?
Yes.
So it is no longer just an understanding, it's now what the parties have agreed.
This document, the front page is saying it's a memorandum of understanding, and I took it as it is.
Yes.
It is not saying agreement. Whether they say word agrees, the letter states the front page of what was signed is saying a memorandum of understanding.
That is the title of the document.
Yes.
And what
They
is
have
an
to-
agreement?
I have to call it according to its title.
According to you, Mr. Kayangela, what is an agreement?
So what you agreed.
Is what you agreed.
Yes.
Now, an agreement is normally entered into between two parties
Can be two parties or more parties.
or more parties,
Yes.
and then they can sign this document.
Yes.
And the document can have different various headings,
Yes.
but the content will dictate what the parties
but
agree to.
In the memorandum of understanding, you can also agree.
Yes. So, like you said, in
But
the
this
memo-
is a memorandum of understanding.
but you. If you objection?
No objection. My Lord, I don't want to interfere with his way of cross-examination, but he needs to be fair to the witness and fair to the court and bring everything before the court. He's relying on one line in the middle of the agreement. You should put the whole agreement, even the conclusion of the agreement, my Lord, which is signed. It's not saying agreed. The parties have reached the following understanding. It doesn't say agreement. So he should not be selected and pick one line and read it out of context with the whole document. It's not fair.
Well noted. That
Your Lordship, all that I'm doing is I'm putting the version of Mr. Esau to the witness. I said this is what is indicated and this is what is testified to. And this is what has been advised that it's now an agreement and this is how it's been changed.
but you also agree that what Mr. Marondez is saying is also correct, that the same document still refers to understanding. Like in various parts of the document.
Indeed so.
Okay.
Indeed so.
I
I'd
also
like to
hear the
indicate to your
witness.
Lordship,
The witness is also saying that in his reply, that in a memorandum of understanding, parties can still agree. So I tend to take it that parties differ on the true
interpretation.
meaning or interpretation of that document.
Now, Mr. Esau was also advised by the permanent secretary that this is a valid, binding bilateral agreement.
Valid, binding.
Bilateral agreement, fisheries agreement between the two parties.
The advice by the Office of the Attorney General was that the Angolan party, they don't want a binding agreement. They prefer a non-binding agreement. But if he was advised so, I don't know why he was advised in such manner.
The
It
permanent
means
secretary.
they disregard the advice they seek from the Office of the Attorney General.
Like I've put to you, Mr. Kayangela, after the advice came back from the Attorney General, there was a further workshop of the agreement for it to be made a binding agreement.
And they say, I'm
Yes.
not aware of those workshops that I just referred to.
Just to be clear, who might have advised that it's a binding fisheries agreement?
The permanent secretary.
Yes. Okay.
And
I
we've
never saw
established,
such advice.
you never saw such advice. Will all the advice of the permanent secretary to the minister be in writing?
I never say it is all in writing.
Yes.
But I say I never saw such advice.
It is normally verbal advice and reports that are provided.
I'm not aware of how this advice was given.
Because what Mr. Esau testified is that he was briefed. I'm just saying he said he was briefed by the permanent secretary. Your Lordship, if my learned friend intends to object, he will
I
object,
have
do
an
not
objection, my
mumble.
lord. I don't know where my learned friend is. He's saying the advice from the permanent secretary is normally in paper. Where does he get that from? Do we have such evidence on this in this court, my lord? He can't say those words.
All right.
Your Lordship, I have instructions. I do not know why my learned friend, if the witness wants to dispute, he wants to dispute. I'm not only referring to everything that was said during evidence in chief, but I also have instructions, and yes, evidence are allowed. And I can ask any question during cross-examination. I'm not misleading the witness.
Maybe just to be clear that it's your instruction.
My instructions.
Yes.
Your Lordship, everything that I'm putting to the witness, at least in this line of questioning, is on my instructions.
All right.
Yes.
That's fine.
So Mr. Esau said that he was briefed by the permanent secretary on this agreement. He
He
also
was
even,
briefed,
yes,
or he was advised. It's a different.
no, before the signing, well, let me break it up for you. He was briefed on the agreement,
Okay.
what the agreement means and what the agreement entails.
Okay.
Okay. Now, Mr. Kayangela, there was then a further letter that was written after this document was signed. It was written on the 24th of October 2014. You can go to bundle 22. Are you there?
The date of the 20th.
The 20th of October 2014.
Yes, I'm there.
That's what? Divider 1, bundle 1, divider 22.
That's
Divider
correct.
22.
Okay.
Mhm.
Yes.
And what Mr. Esau came to testify is this letter was again then also prepared for him. By the permanent secretary. If any comment on that?
The comment is only to say that the inquiry person on this letter is Ms. Anna Erastus.
Yes. And she was the director of policy planning.
Just repeat your answer, Mr. Kanyangero.
I sent on the face of the letter, the inquiry person in this letter is Ms. Anna Erastus.
Okay.
And there's no any indication to say that it came from the office of the permanent secretary.
What he further indicates is that in terms of Section 35 of the Act, the Marine Resources Act, the President may conclude fisheries agreements with SADC member states to harvest marine resources in Namibian waters. Under Section 3, Subsection 1 of the Assignment of Powers Act 1990, the President has authorized the Minister to sign the agreements between the Republic of Namibia and the Republic of Mozambique and the Republic of Angola, respectively.
Yes, I follow.
Yes. With respect to the agreement with the Republic of Mozambique, the Minister of Fisheries and Marine Resources has delegated that the then Deputy Minister sign on his behalf, the agreement between the Republic of Namibia and the Republic of Mozambique. The Minister of Fisheries and Marine Resources, in so doing, was empowered to act under Article 37 of the Namibian Constitution. He goes on to state that, and I will skip the first part. No. Further, in terms of Section 36 of the Marine Resources Act, the President must publish by proclamation any such fisheries agreement so concluded. Therefore, the two fisheries agreement having been concluded, it is my pleasure to request that you certify the attached draft proclamation for HE, the President's signature and publication in the Gazette. If you turn the page, therefore, the two fisheries agreements having been concluded, it is my pleasure to request you to certify the attached draft proclamations for the HE and the President's signature and publication in the Gazette.
I'm following.
Yes. So what Mr. Esau is saying, and it's also evident from this particular letter, that he was under the impression that it was a fisheries agreement, and that is also how he has been briefed. And that's why he referred to a fisheries agreement in this letter, in terms of Section 35 of the Act, concluded in terms of that section.
Yes, whether
No, my Lord, I just want clarity from a learned friend before the witness answers. The first part of the question was that this letter was prepared for him. Now he is saying, Mr. Esau, that's why he prepared this letter. Now we want to know who prepared this letter. Is it Mr. Esau or it was prepared for him?
Okay.
Permanent Secretary.
just ask the question again.
So in terms of this particular letter, as prepared by the Permanent Secretary, it refers to fisheries agreements, and that includes the one with Angola.
I will still say that on this letter, there is nothing that shows that this letter was prepared by the Permanent Secretary. Anna Erastus, who is an inquiry person on this, is not a Permanent Secretary. She was not a Permanent Secretary.
This letter
I don't know
refers,
what it is indicating, that it was prepared by the Permanent Secretary.
let's park the issue of preparation by the Permanent Secretary. This letter indicates fisheries agreements that is concluded in terms of Section 35 of the Act.
Gas fisheries agreement can be concluded under that section.
And part of this letter, those agreements that were signed with Angola on the one end, and the other one that was signed with Mozambique, was then forwarded to the Attorney General for publication, the President's signature and then publication.
That's correct.
And he was requested then to advertise it in the Government Gazette, the proclamations, as fisheries agreements.
That's correct.
So the impression that these letters at least create that even if the minister signed it off, that it was, and as he has testified, as he was briefed, that it was a fisheries agreement.
It was not a fisheries agreement. What I know, there was a summary of all the agreements that the ministry entered into with different countries. In this agreement that they have signed, or the memorandum of understanding that they have signed, it was still indicated as a memorandum of understanding.
That is the title of the document.
Yes.
We are now dealing with this letter.
The letter is referring to fisheries agreement.
Yes. And when
It's because what is have been provided in the Act. That section is referring to fishing agreements.
to the fishing agreement,
Yes.
and then it will be published in terms of section 36 of the Act.
That's correct.
And then it was published as an agreement through Government Gazette notice.
It was published as a memorandum of understanding.
Let's go there. Turn the page, Exhibit P, number 23.
Yes.
Proclamation. No?
Be specific, Mr. Beerkas, that is still bundle 1.
Bundle 1, Exhibit P, Your Lordship.
All
My
right.
apologies.
Yes.
Yes, I see the proclamation. Why it was referred to as a fisheries agreement?
Dr. Kangela, can I finish my question?
Okay, you can
Yes.
finish.
So, in terms of Exhibit P, it was published as an agreement between the Government of the Republic of Namibia and the Government of the Republic of Angola on cooperation in fisheries and aquaculture, Marine Resources Act 2000. And then there's reference to Article 36.
I could not see the refer. Oh, okay.
Yeah, just in terms of
No, I can
Article
see.
36, I published the agreement.
Yes.
Yes. So there was a letter asking for it to be published in terms of firstly, the letter that we just went through indicates that there's a fisheries agreement. We want this fisheries agreement to be published in terms of section.
But there was that was a misleading. Because
Kangela,
what
you
was
must
sent,
allow me to finish my question.
I thought you finished. Okay, I will allow you to finish your question.
You will allow me.
Mhm.
There was a letter that referred to a fisheries agreement
That's
to be
correct.
published in terms of section 36. There was then a publication that refers to an agreement in terms of section 36, correct?
That's correct.
Yes. In your investigation, do you know whether the Attorney General responded to this letter of 20 October 2014 and come back to the Minister, Mr. Esau, and advise him that, no, you are wrong. It is not a fisheries agreement in terms of section 35. After this letter and the request for the publication as a fisheries agreement.
I'm not aware whether Mr. Esau went back to him
No.
for advice before he sent this letter, or before he asked for the publication. I'm not aware whether he wrote any other letter to the Office of Attorney General seeking such.
Just listen to the question, Mr. Kayangela. The AG was provided with a letter referring to a fisheries agreement, asking for him to publish a fisheries agreement, the one between Namibia and Angola. He then published it. After that, did he come back, or to come back in your investigation, could you establish whether he came back to the then minister to advise him that no, it is not a fisheries agreement, we are wrong, we can't publish it as is?
Fisheries agreement and the memorandum of understanding on fisheries and aquaculture they can all be fisheries agreement. There's a fisheries agreement, there's a bilateral agreement. There are two things. And what was submitted to the Office of the Attorney General, it was a bilateral agreement to be signed. Then he advised for it to be a memorandum of understanding.
No, what was sent to him was a memorandum of understanding.
Yes.
But just listen to the question, Mr. Kayangela. We will stand here the whole day.
Yeah, we can stand
Yes.
the whole day night.
If the Attorney General received a letter referring to a fisheries agreement, and to publish this fisheries agreement, certainly as the Attorney General, he should have come back and said, but this is not a fisheries agreement. I will not publish it.
I don't know what was provided to him, whether it was agreements, because the letter is saying that draft proclamations. That is what was submitted. It never say attached. He said he must certify the draft proclamation.
No, you must first certify the draft proclamations.
Yes.
And if you go to the last sentence, please find here to attach copies of the signed agreement for your attention as well.
Yes, I can see
Yes.
that.
And what is published is the agreement. Is it not so, Mr. Kayangela?
It is so.
Yes. So the Attorney General then received these agreements. He was asked to publish them as fisheries agreements, and he went ahead to publish them in terms of Section 36 as fisheries agreements.
Yes, but what was provided to him is a memorandum of understanding.
But yet him, with all
That
his
is the
wisdom
one
and
that was
legal...
sent.
Sorry?
And that is what was sent.
That is what was sent to him.
Yes.
And he did-
Memorandum of understanding.
Let me allow you to finish. Sorry, I interrupted you. You can finish?
And I cannot say as to why he accepted.
Could it be because he considered it to be a fisheries agreement, that's why he published it as a fisheries agreement?
That must be found from himself.
Yes. But at the end of the day, the chief legal advisor of the government of the Republic of Namibia published this document that you're now referring to just as an MOU. He published it as a fisheries agreement. Is it not so?
It is so.
Your Lordship, I believe that that would be a convenient time for us to, before I move on to our next topic, to adjourn for the day.
That's fine. We'll proceed with the matter tomorrow, the 30th of August 2023 at 10 o'clock. Court adjourns.